Right, good afternoon everyone and welcome to this month's webinar from HR Solutions. The topic of interest today being to highlight the contractual changes that have materialised from the government's Good Work Plan. Welcome to all of you listening and watching to this webinar today. Whether you're working from your usual location, working from home, perhaps keeping up to date whilst furloughed or out of work, whatever your situation, you are all really welcome. And we always start by introducing ourselves. So just for those who haven't joined us before, and so you can know who we are and who you're listening to. My name is Abby Ashford, and I shall be your presenter today. Sue Watson is also here with us in the background. And we have my colleague, a team in the background, also to field any technical questions you may have during the webinar. The team will be monitoring and collating questions, so do please feel free to send her a message and then I will email you a response after the webinar has concluded. As always, we are recording this session, so it will be available for you to watch again if you wish to, and to share with colleagues if that would be helpful. If anyone wants to contact us afterwards for a copy of the presentation slides, then please note that you are very welcome to do so using the inquiries email address confirmed at the end of the webinar. Okay, so our agenda for today for this webinar is first of all to look at what has changed and who this applies to, then to confirm how best to implement these changes. I'll then make it clear what you were meant to be adhering to so as to confirm what the additional mandatory requirements are now in a written statement and which terms absolutely have to be included up front as opposed to being signposted. My final slides will be to give you 6 next steps to consider and a final point towards risk of non-compliance. Okay, so with effect from this week, that's 6th of April 2020, the entitlement to a statement of terms and conditions has been updated to extend to all employees and now workers from the first day of employment. Previously, the written statement was to be issued to employees only within 2 months of their start date of employment. From the 6th of April, the written statement must be provided now as a day one right. Previously, if employment was for a period of less than 1 month, there was no right to a written statement. But from 6th of April 2020, all workers are now entitled to a written statement regardless of the length of their employment term. The entitlement to a statement of terms and conditions has been updated in the Employment Rights Act 1996. The extension to apply to workers is also significant as previously workers were not covered in this section of the Employment Rights Act as being entitled to a written statement. The updates have been detailed in the Employment Rights Miscellaneous Amendments Regulations 2019. And it is these further specifications to the terms and conditions of a written statement that I will take you through in this webinar. But first, now that we have to provide a statement for both employees and those defined as workers, let me delve into this change for you first. Employees and workers have differing definitions within employment law. The Employment Rights Act 96 defines a worker as an individual who has entered into a contract of employment or any other contract under which they undertake to perform personally any work for another party to the contract whose status is not that of a client or customer. Breaking down that definition, the term worker includes not only employees, but also an individual who has any other contract, whether express or implied, whereby he or she undertakes to do or perform personally any work or services for your business, but where you are not a client or customer of any profession or business undertaking carried on by the individual. Existing workers, who are not also employees, do not have a right then to receive a written statement for their current engagement that began before the 6th of April 2020. If they are re-engaged by the employer after the 6th of April, then the rules will apply and they will be entitled to a written statement from day one of that re-engagement. So to be clear, there is no change for existing workers. The only scenario where you would need to provide a written statement for workers is if they are re-engaged after the 6th of April 2020. Existing employees can request an updated statement from their employer. If requested, the employer must provide an updated statement within 1 month of that request. Be aware that the request does not have to be in writing, so if the employee emails you, calls you, speaks to you verbally, or indeed requests in writing, the statement should be provided within 1 month. Again, to be clear, that is for existing employees. If there are any future changes to terms and conditions after the 6th of April 2020 now, the employer must provide a statement of change to the affected employees. It is advisable to confirm any contractual changes in writing to detail the change itself and the date the change is effective from. Written confirmation can avoid any misunderstanding or ambiguity. The written confirmation should also confirm the method of communication of this change and the manner of agreement sought with the employee to avoid any future disagreements with regards to terms or changes to them. Any changes to terms and conditions that are detailed within the contract must be conducted through a consultation process with those affected to avoid any claims for breach of contract. Again, to be clear, this is only if you want to take the opportunity of updating the terms and conditions that all employees are engaged on. For further clarity then, these were the essential minimum pieces of information to be included in a written statement, some of which had to be included in one principal document. Others, you were able to refer the employee to a separate document. You may have held the practice of giving just this information and it being called a written statement of main terms and conditions of employment. Some employers want more information in such a document, perhaps more weighty clauses, such as post-employment restrictions and bonuses, and so they instead draft contracts of employment. A statement is not necessarily contractual unless the employee has signed to clearly indicate his or her agreement to the terms, as opposed to signing to indicate receipt of a statement. But these were the minimum details pre-6th of April 2020. On my next slide are the additional elements for a written statement now. This slide is a little wordy, but so that you have these new basic terms all on one slide, these are the terms that must be included in the Statement of Terms and Conditions of Employment from now on. Remember, this update is a result of the Good Work Plan, itself a result of the Taylor Review for the government, with the main focus on allowing new hires to enter new employment with their eyes open, knowing fully what hours, what days they were expected to work, not only what holiday and sick leave entitlement they would have, but any other benefit too, whether they would be on a probationary period initially, and what the terms of that was, and if there was any mandatory training to successfully complete, whether that would be provided or not by the employer. But note, some terms can actually be provided in instalments, and some parts of the statement can just signpost the employee. So let me walk you through those two aspects now. Firstly, certain particulars may now be given in any number of instalments, in addition to the initial main statement. Instalments do not have to be given together at the same time, but must be provided to the worker not later than 2 months after the beginning of the employment. The particulars that can be given via an instalment statement are terms and conditions regarding pension and pension schemes, details of any collective agreements which directly affects the terms and conditions of employment, details of any training entitlement provided by the employer, but not details of any compulsory elements of that training, or details of compulsory training that the employer will not pay for, and the note regarding disciplinary rules and disciplinary and grievance procedures. Secondly, the written statement may refer the worker for further details of certain prescribed particulars to either the provisions of some other document that is reasonably accessible to the worker, or the relevant section of the law, or to the provisions of any collective agreement directly affecting terms and conditions of the employment that is reasonably accessible to the worker. When it refers to reasonably accessible, this means a document or collective agreement which the worker has reasonable opportunity of reading in the course of their employment, or is made reasonably accessible to the worker in some other way. For example, you might have a document such as a family-friendly policy that employees have access to. You might have a specific agreement, like a training agreement, again, that people can have access to, or an employee handbook, for example. The terms that can be provided in detail in this way include any terms and conditions relating to incapacity for work due to sickness or injury, including sick pay, any terms and conditions relating to any other paid leave, any terms and conditions relating to pensions and pension schemes, any training entitlement provided by the employer, but not details of any compulsory element of that training, or details of compulsory training that the employer will not pay for, the notes of the disciplinary rules and procedures, but details of the person to whom the worker can apply if dissatisfied with any disciplinary decision relating to them, or any decision to dismiss them, and the person with whom the worker can raise a grievance must be set out in the written statement itself. The notes of the disciplinary appeals process and grievance procedure, the details of the length of notice which the worker is obliged to give and entitled to receive to terminate their contract. The employer can refer the worker to the law, for example, the Employment Rights Act 96 regarding statutory minimum notice, where the worker's notice period is the statutory minimum, or finally to the provisions of any collective agreement directly affecting the terms and conditions of the employment, which is reasonably accessible to the worker. What if there are no particulars then for one of these mandatory new terms? If there are no particulars to be entered in certain terms of the written statement, that fact must be stated in the written statement itself. For example, if there is no probationary period applicable to the worker, the written statement must include that information. A simple example shown on the screen, whereby clause 4, headed probationary period, determines that no probationary period is applicable to this role. Again, going back to the good work plan ethos, it is all about the new hire knowing what they are taking on, and if there is no probationary period, as in this example, it is abundantly clear. They know that they will not suddenly be hauled into a meeting after 3 months and dismissed for a failed probationary period, because none applies. I will now take you through 6 steps of what we consider are the actions required should you not have addressed this change to mandatory terms as yet. Whilst we have known this change has been coming for a while now, and certainly has been the content of some of our previous webinars where we gave the heads up, you may have already made changes. You may not have needed to make any changes, or indeed with focus taken up by dealing with the impact of COVID-19 on our organisations, this may have slipped down the priority order, especially for the majority of employers who are not hiring and haven't done so for a few months now. But trying to stay positive, some employers are hiring and some employers are now finding time as their workloads decrease to focus on tasks that need doing like this. So let's have a little look at what we recommend. First of all, review your current documentation to update templates to include the additional terms that must be included within the written statement now, taking into consideration that even if the new term isn't relevant to the role, this should be clarified and that some terms can be signposted, whereas others have mandatory minimum content as discussed on my previous slides. Step 2 then, review all your current contracts and agreements in place with all of your workforce to establish who would be entitled to a written statement under the new rules. Flag any existing employees who have not been provided with a written statement yet and ensure they receive one that is compliant with the new rules. A third step would be to review the status of all workers to identify who is an employee and who is a worker. Note now that if you engage workers, as we are already after 6th of April 2020, they will be entitled to a written statement from day one, no matter how long you are engaging them for. A fourth step might be that if you do have any new starters upcoming, to have a look at which are employees and which are workers and who will be entitled to a written statement from day one of their employment. Step 5. If you do have any new hires due to come on board, review any upcoming new starter paperwork and be ready to ensure that any new employers or workers has that written statement from day one. Reviewing all training carried out within the organisation also, across all parts of the business. Identify any training that is compulsory and any other compulsory training that you do not pay for. And finally, ensure all managers are aware of the new legislation and requirements and that they must make appropriate arrangements for staff who request an updated statement, even if that is by email or verbally. So what's the risk of not doing anything? Well, if the employer fails to provide a written statement and there is a dispute that ends up in tribunal about it, the claimant can ask the tribunal to make a determination of what the particular term in question would have stated in order to hear the claim. If an additional claim for failure to provide the written statement is made alongside a claim, the tribunal may award the claimant 2 or 4 weeks' pay, whichever the tribunal sees as fit for the case, subject to the weekly salary cap in place at the time, which at the moment is £538. Well, that is the end of our webinar today. For those listening and watching who are already clients of ours, thank you for joining us again. Please do contact us in the usual way if you have any follow-up queries. And if you aren't a client with us but would like to ask a question or are interested in our services, then please do contact us at inquiries@hrsolutions-uk.com. You can also use this email address to request a copy of our slides to watch, listen, forward on, and you can do that by heading to our main website at hrsolutions-uk.com and clicking on resources and then the video and webinar archive. So next month, You can sign up on the events page on either Knowledge Base if you have access to that, or on our main website. And the next webinar we have planned on May the 12th is looking at recruitment and the importance of the candidate experience. This webinar and all of our previous webinars are recorded and can be found on our website. The link is on the slide, and I've listed previous webinars too. If you've not already signed up to our e-newsletter, then this is just a reminder of the link. Signing up will mean that you get to hear about our latest webinars and events first, and also keep abreast of any other developments. We have a free HR risk and compliance audit online on our website. The link is on the screen now. Each audit taken will generate a bespoke report based on your responses, allowing you to focus on any areas that need attention. All I have left to say is thank you for listening, and I hope you have found today's webinar informative. Thank you.